All right, today is September 11th, 2012, and we're done talking about the course design. We're done talking about the grading protocol. I want to just introduce your first reading and get a little bit ahead here since we have a little bit of time and begin the substantive part of the course. Your text, by the way, is by Kathleen Fowler. It's called Interviewing Children About Sexual Abuse. Is there someone who doesn't have the text yet? Okay, you should get the text as soon as possible. Thursday? Good. They should be available online, and they're certainly available as an ebook. I'm looking at it as an ebook, but there are hard copies as well. Professor Fowler wrote this book in an effort to describe the state of forensic interviewing. I think it's from 2007. And not much has changed since she wrote the book. And what I like about it is she looks at forensic interviewing throughout the U.S. from a variety of perspectives. She identifies a number of different protocols. She doesn't promote one protocol over the other. I will do that. I will promote one protocol over the other because I believe in one more than the others, but she doesn't do that. So it's a broad perspective of forensic interviewing in the United States, and I think she does a good job with it. And at the end of each chapter, you'll notice she does a little bit of a summary, and at the end of each chapter, she offers special notes about what we've learned, and I would focus on those things. They often drive exam questions, those kinds of things. So the first thing she opens up with in Chapter 1, which you are supposed to read, and it's one of your assignments, is, as the chapter title tells us, Forensic and Clinical Interviewer Roles in Child Sexual Abuse. What are the roles for a forensic interviewer and a clinical interviewer in child sexual abuse? Okay? Now, you don't have to follow along with the book. You could, but it's up to you. You don't have to take notes, but you could. And
you don't have to come to class.
No, you have to come to class. That's the one thing. But I'll be posting this online, and you certainly can listen to it at your convenience if you choose. Professor Fowler says, who interviews kids for sexual abuse? What kinds of professionals? Well, she starts out by telling us there's professionals from a range of disciplines in a variety of work settings who may need to determine whether a child was sexually abused or not. And, I often make this observation. It doesn't matter really what your discipline is if you want to do a forensic interview with child. Cops can do good forensic interviews. Child protection workers can do good forensic interviews. Certain cases, a lawyer can do good forensic interviews. What's important is that you understand how children develop. You understand their ability to recall events. You understand the impact of suggestive questioning on children's memories. You need to know a little bit about a variety of disciplines. So no one discipline is in a better position than any other discipline. If you say, well, I'm a psychologist. Well, a psychologist who interviews kids needs to know something about law enforcement. They need to know something about the potential for children to be misled by suggestive questions. They need to know something about the research on false allegations in child abuse. They may be a psychologist, but they need to know something about the linguistics. They may need to know something, they have to know about a variety of things because it is a multidisciplinary approach that results in a good outcome in the forensic interview of children. You simply can't focus on one discipline or the other. You need to be aware of a variety of issues and dynamics that surround child interviews. So, Professor Fowler says, listen, professionals from a wide range of disciplines may need to determine whether a child was sexually abused. They may be doctors, nurses, mental health professionals. They may be social workers, psychologists, psychiatrists, lawyers, police officers, detectives, and the like. They have very many backgrounds. Whatever the background of the interviewer is, whatever the purpose, right? A doctor may rely on a social worker to interview a child because they need to conduct a medical evaluation. So a doctor needs to find out the historical truth the best they can. They need to find out what happened. What did this child experience? In the medical context, that's called taking a history. Think about the last time you went to a doctor. Somebody said to you, "Why are you here?" And you gave them an answer. The answer you gave was the history. I fell down the stairs. I fell off my motorcycle. I ate something last night and I have severe stomach pain. Whatever it is, you're giving a history. You're giving information from the past about what you experienced so the doctor can make a decision about treatment. Kids who may have been sexually abused go to the doctor for a medical evaluation. We'll talk more about medicine and child sexual abuse later, because it's very rare that we have actual findings, but there are a variety of reasons why you would have a child medically examined. It's not only to find forensic evidence, it's to make the child feel good about themselves, it's to conduct a general wellness interview, to look for other indicia of sexual abuse that are non-diagnostic. Well, that sounds kind of in conflict there, but you may look for other sensations that the child is feeling that are marginally relevant to sexual abuse or have some diagnostic meaning. But kids get examined by doctors when there is an allegation of sexual abuse. And when they take a history, they're gathering information. They're conducting, in a way, an interview that's forensic in nature, because it may wind up in a legal proceeding. Psychologists may interview kids when they conduct a psychological trauma evaluation. See, the medical doctor is looking for physical trauma. The psychologist or the clinical social worker or the psychiatrist, they're looking for mental health trauma or psychological trauma. They're getting a history too. We call those kinds of evaluations in New Jersey psychosexual evaluation. Now, they call them different things around the U.S. They're a mental health evaluation. But the mental health professional who does it is conducting a forensic examination, a forensic interview. While their goal is to find out whether this child has suffered trauma, which they usually do, and what the nature of that trauma is, the depth of that trauma, the information that they develop has the potential to wind up in a legal proceeding, and almost always does. So the doctor who interviews the child is looking for information. The doctor who interviews the child needs to know the historical truth to treat the child. Their focus is on physical trauma. The mental health professionals interviewing the child because their focus is on psychological trauma. The forensic interviewer who works for the prosecutor's office, they're interested in what happened to the child. They're interested in the historical truth, not to treat them medically or psychologically, but because they want to determine whether there was a crime committed. And if there was, whether the case is prosecutable, whether there's enough evidence to hold a person responsible for the sexual abuse. Although their roles are different, they're all interested in the historical truth. And they're all doing a forensic interview. Professor Fowler even breaks it down into forensic versus clinical practice. And she says that there are certain organizations that publish guidelines for interviewing kids in a clinical environment. The American Professional Society on the Abuse of Children, the American Academy of Child and Adolescent Psychiatry, and there are a number of different views on clinical practice versus forensic practice. Now, you heard me say a moment ago, the medical doctor interviews the child because they want to give treatment for physical trauma. The psychologist or mental health professional interviews the child because they want to treat for psychological trauma. The detectives or law enforcement interview the child. They want to see if someone's culpable or responsible and might be prosecutable. In those cases, they're doing forensic interviews. Even the psychologist who interviews that little girl once to do a trauma assessment is doing a forensic interview. That's different from the psychologist who treats the child. There needs to be a separation. The criminal law requires that. The civil law requires that. Because if you're the same person treating the child who did an evaluation of whether the abuse occurred or not, they did a trauma assessment to find out or conclude whether this child indeed suffered trauma, then you're involved in dual roles. Because a treating therapist is someone who accepts what their patient says. They're a little less interested in the historical truth than someone who's doing a trauma assessment. And I don't know that I'm saying this effectively enough. A kid goes to a special psychologist who spends a day or two with them, maybe has a series of interviews over a couple of weeks, and they're done. They issue a trauma assessment. They're trying to determine if this kid was abused, and if they were, what the extent of any related trauma was, so they can be treated by someone else. The someone else is the therapist who treats them. Now, there's no law against that, but it is very prickly when you wind up in the civil or criminal courts if you are not only the evaluating clinician, but also the treating clinician. Because that treating clinician owes their complete loyalty to their patient. Yet they may have to come to court to testify about the integrity of that child's original disclosure or any other statements they made and undermine that child, hurt that child, say things that are against that child. And it, like I said, it becomes very problematic on cross-examination and for the therapist who testifies, who is a forensic evaluator and also a clinician who's treating the child. It's happened a few times in New Jersey. There's been some criticisms of those kinds of dual roles. You're just setting yourself up for problems. So what most organizations and what I strongly recommend is have a psychologist do an evaluation and have some other psychologist treat the child. Go ahead.
Well, it not only compromises the client's confidentiality and disclosure, but it also puts in question the integrity of that psychologist as a therapist to that individual client. Because now every other client obviously is going to know because they were in court, it's a case, and they're going to be kind of, opposed to the treatment that they're getting. It's not completely loyal.
Yeah, well, that's a great observation. And what I was suggesting before wasn't that there's problems with client professional confidentiality when you assume dual roles, when you're an evaluator and a treater. There are exceptions to confidentiality. The therapist is going to be compelled to testify many times in criminal and civil prosecutions. What I'm talking about is, and you made a similar observation a moment ago. What I'm talking about is you're treating this kid. Maybe it's a teenager, a little kid, whatever. You're treating this person week after week after week. The basis for treatment and cooperation and success in large part is based upon trust. It's based upon a special relationship between you and that patient. To then come into court and to have to explain your suspicions when you first evaluated her, to testify about the credibility of that child's accusation, number one, could serve to undermine clearly the relationship between you and that child, because you're now going to say things that suggest you don't trust the child, you don't believe the child in certain aspects, perhaps. But the other thing is, a defense lawyer is going to say to you, for example, well, isn't it a fact you're the treating clinician? Yes. Isn't it a fact that not only are you biased towards that child, you are compelled to be biased towards that child? Isn't that correct? Isn't your role, one, to do no harm to that child and do everything in that child's interests? That's correct. So, we're never going to suggest, ma'am, that you're intentionally deceiving us. But everything you say here today is going to be filtered through your perspective to help that child. You are not completely objective. Yes or no? Well, I try to be objective. The question is, you owe loyalty to this child. That's your patient. Is that right? Yes. You cannot say here today that that doesn't influence your recollection of what happened in the past and your opinions about things. Isn't that true? Maybe it is, maybe it isn't, but you're going to get involved in a dance like this for an hour. And they're going to do a better job than I did just now, because they're going to know more about you and they're going to know more facts. And the bottom line is, you're not objective. You're not. You know the kid. It's like you coming in and testify about your mother, your father, your daughter, right? That doesn't mean you can't be a witness in a case that involves your mother or your father, but, defense lawyer, either gently or aggressively, is going to go, well, that's your daughter. You don't have to say anything more to the jury. Look, she's going to come in and she's going to say what she remembers, but everything she remembers is going to be colored through the parent-child relationship. She's inherently biased, and that's okay. I had a mother too. She loves me. She'd never throw me under the bus. She'd never betray me. Her memory is going to be the memory that protects Joey. That's the way it is. It's the way it is. So if you're in a clinical relationship with a child for 27 weeks, 3.5 years, you owe that child your undying loyalty and support. And you're walking into the courtroom biased. So the recommendation is, don't be the evaluating clinician and the treating clinician. Because sometimes judges order, although it's not allowed in the criminal courts, they order a psychologist to evaluate the kid. And they say, we want to report on whether the child's, whether in your expert opinion, the child is being truthful about the allegation of sexual abuse. You can't do that in the criminal courts in New Jersey. But you can do it in the family court, you can do it in the civil courts, you can do it in a variety of legal proceedings, where it's not dispositive. The judge doesn't go, aha, well, the doctor said it must have happened. The judges want expert opinions, and you're going to get an expert opinion on the other side, and you're going to get another expert opinion, and the judge has something to look at and decide whether they find this opinion better than the other, or whether the expert noticed something that they didn't notice. So the expert opinions are helpful. So if the judge orders a clinician to do a evaluation of a child and to make an opinion about whether the child's statements are trustworthy or believable, the wrong person to do that is the person who's treating that child. I think they come in and go, well, don't quite believe her, but I am treating her. You're not going to have that. It is a Hobson's choice that a clinician is faced with when they have to testify in that context, and it's highly problematic. It creates a dilemma that has no answer in very many cases. This case, some of you, I don't know if there's anybody here, but some of you, maybe you heard of a case that was a notorious prosecution in the 1980s. It happened in suburban Essex County in Glen Ridge, New Jersey, where a group of high school football players raped a developmentally disabled girl. And they gathered around in one of the boys' basements. They took off her clothes. They all took turns having sexual acts upon her. They put bottles and toys and objects into her body parts. And they were indicted and prosecuted. It was called the Glen Ridge rape case. It was in the cover of Rolling Stone magazine, the New York Times for months and months and years, and it was prosecuted, and they went to jail, and they were convicted. One of the clinicians, who's a colleague of ours and a friend of mine, had to answer a question for the court. She was hired to determine whether the girl was so developmentally disabled that it impacted her ability to provide meaningful consent. Because if she was 16, so she was over the age of consent in New Jersey. Unless it's a teacher or father or something, you've got to be 18. 16 is the general age of consent. So if she was 16 and normal functioning, and she wanted to go in the basement and have everybody do whatever they did to her, and that's not a crime. Because there was evidence that she did all these things that, without peeling away the layers of what motivated her, if you just were a fly in the wall, it looked like she wanted to do all this. In the end, when she was evaluated psychologically, she liked one of the boys. I liked Kyle. And if Kyle said to do the other boys, I did the other boys. Oh, yeah, I wanted to do it because I like Kyle. So she allowed herself, as Glenn Goldberg called it, to be almost a science experiment because she liked one of the boys. Now, the prosecution's argument was that's not normal thinking here. And there was evidence that she had she was developmentally disabled. But just because that was what was known around the community, you needed to have expert testimony. So the witness who testified about the level of her cognitive impairment was also the treating clinician. And the defense lawyers went after her with a viciousness that's unparalleled in New Jersey cross-examination. And what did they focus on? You came to court and you spoke to this young lady and you wrote a report and said that she is developmentally disabled and it is so significant that it impaired her ability to give meaningful consent. Right? That's one of the elements of the crime. Otherwise, it's not a crime. And you have also been treating her for the past 2.5 years. So they went out of their way, as they should, to show that she had the potential to be biased. Of course you're going to say she's developed. You got a horse in this race here. It's in your interest for her to be that way. You're treating her for that. So
why did they hire her? If she had already been treating her, why would they say, oh, you're the best person to do this?
Well, because this was the 1980s. A lot of things happened in the 1980s involving the investigation and prosecution of child abuse that were new. We didn't know what we didn't know, and it wasn't the right decision, arguably. There were convictions, and they were legitimate convictions. It's not the Kelly Michaels case, which we'll examine later, which that conviction is highly suspect. But nobody thought about these things. Like, oh, Dr. Esklin her videos are here. She's brilliant. Dr. Esklin is one of my heroes. But so the prosecutor said, hey, let's get her. She's the best, man. But they got her to do both things. And nobody really thought about what cross-examination would be like. I mean, this was new territory. Nobody tried these cases. 1960s, nobody tried cases like that. A girl who had sex with 10 boys. That was just not... It wouldn't be tried. It was the mores and the culture and the way people thought about human sexuality and the prosecutability of cases was quite different. It wasn't until the 1970s that we began to look at women and gender and sexual relations differently. And we looked at sexual conduct as potentially assaultive rather than a family offense or an offense against property. You read the MTS case. No, that's in the other course we teach. But anyway, so things were different then. We learned from that case. Now, it may seem obvious to us now, because I am banging the table saying that it's not a thing we should do, but it wasn't obvious to anyone back then. They just said, go get us the best person possible. And they got one of the towering giants in the field of child sexual abuse. But they got her to do both things, so she was vulnerable. She stood her ground, but, there was 2 hours of vicious cross-examination. Where in the end, you really couldn't say that she didn't have a bias. Of course she does. She cares about this kid. She ought to care about this kid. She's compelled to care about this kid. She's compelled to come in there with a point of view that favors that child. Well, that's not objective in the courts. But that doesn't mean she couldn't testify. No more than your mother could be prevented from testifying. We'll just say, hey, you're her mom. Take it with a grain of salt. Anyway, it's approaching time to leave. Unless you hear otherwise from me, we will meet in this same room here. I'll see whether I can get the key to this cabinet. I was blown off by tech support, so I'll try way in advance next time.
They said they don't have a key. You have to ask
It's a-
honors program.
Yes, that's kind of what they said to me. It's not their jurisdiction.